Hello everyone, today we'll deal with section 27 of the Indian Evidence Act. How much of information received from the accused may be proved. So the information or the confession statements made to the police officer is not admissible or irrelevant. So how much of information from that confession received from the accused may be proved. So provided that. So here the section starts with the expression provided, which means it is a proviso. So it is an exception. Exception to what? This provision is an exception to the three preceding sections dealing with confessions, namely 24, 25 and 26. So now let's come to the section provided that when any fact is deposed to as discovered in consequence of information received from a person accused of an offence in the custody of a police officer, so much of information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered may be proved. So according to section 24, a confession which is made on account of any inducement, threat or promise is irrelevant. Section 25 says no confession made to a police officer shall be proved as against a person accused of any offence. And according to section 26, no confession made by an accused while he is in police custody shall be proved as against the accused person unless it is made in the immediate presence of a magistrate. Here section 27 is an exception to the three preceding sections. It means to say that where information is given by the accused while he is in police custody leads to the discovery of any incriminating material object, that much portion of the information can be proved under section 27. Not the entire confession, but so much of information received is proved. And information given by the accused while in police custody leading to the discovery of incriminating material would be admissible irrespective of the fact that whether such information amounts to a confession or not. So it doesn't matter it is confession or not. Suppose, let's say an example, confession made by a accused person in the presence of the police officer shortly after the murder, that I have committed the murder, I have hidden the weapon at the place X. So the leading to the seizure of the weapon of the offense is admissible because it leads to discovery of the fact of the murder weapon. So now let's see the conditions for the section 27 admissibility. First is there must be a discovery of fact. Second, the fact must have been discovered in consequence of the information. Thirdly, information must have been given by the accused while he is in the police custody. Fourth, so much of the information which distinctly relates to the fact thereby discovered may be proved. So now let's see discovery of fact. Fact here means physical facts and not psychological facts. The facts which was not known earlier to the police, those are only admissible, and there must be discovery of any material object. Let's see an example. Suppose the accused has been brought for murder. In his confession he stated that he has hidden the stained knife in the backyard of the house. Subsequently it was found. So the information that led to the discovery of the stained knife is admissible here. Again, the fact must have been discovered in consequence of the information. Suppose if the accused, without passing any information, simply takes out a weapon with which he has committed the murder and gives it over to the police, then no evidence can be given as to the discovery and it is not admissible. There something must be new in the information. Suppose in another example, the eyewitness said that murder was committed in the place X or where the weapon was thrown, and the accused subsequently then gives information about it. It is not admissible because it was known earlier to the police by the eyewitnesses. Let's see another example. Suppose A, B, C and D, the four accused, are for the murder of E. A gives first information to police that he stabbed E and concealed the knife in the place X. Subsequently, B, C, D too also repeated the same statement as given by A. It can be proved against A only as he gave the information first and not against B, C, D because the police knew first from the statement of A. So the fourth ingredient is so much of such information which distinctly relates to the fact thereby discovered may be proved. So what is so much? So much is that portion of the information which actually leads to the discovery of the fact is provable. In an example, suppose I have killed X. It is my confessional statement. I have killed X and I have buried the dead body in my garden. So here I have killed X, the first part is not provable. But I have buried the dead body in the garden is provable because it is the so much of information or the portion of the information which actually leads to the discovery of the dead body. So it is provable. So now let's see the leading case of the section 27, that is Pulukuri Kottaya versus Emperor. In this case, Kottaya and 17 others were tried for the murder of Sivaya and Subaya. Here the third and the sixth accused gave information while they are in the police custody that led to the discovery of the murder weapons. The statement of the third accused was that I have stabbed Sivaya with a spear. I hid this spear in a yard in my village. Also, the confessional statement of the sixth accused was that about 14 days ago, me, Kottaya, and our party people waited for Shivaya and Subaya, and when they came, we all beat them to death. One Ramaya gave me a stick. I hit stick in wake of Mr. X. We all did at instigation of Kottaya. Here the Madras High Court convicted all of them, but the appellants preferred an appeal before the Privy Council. The Privy Council held that the third accused statement must be discarded and the sixth accused confession is inadmissible. And the Privy Council remitted the case back to the High Court with the direction that see after discarding the inadmissible evidence whether the conviction can be sustained or not. So the fact discovered here not only includes the physical object produced but also the place from which it is produced and the knowledge of the accused as to this. This was also held in this case. So this is all about section 27 of Indian Evidence Act. Hope you all will like it.